Good afternoon. This is the last section. This is the last session, but I think it's one of the most interesting sessions in my opinion, and not because I presented. So, in my presentation, I understand the topic of economic sanctions is very loaded these days. Everyone is talking. There is a lot of literature. So, one of the goals of my presentation is to bring a little bit more clarity and more structure in explaining this topic and explaining you how it's complex and how many legal questions are buried under this notion of sanctions, and how a lot of creative thinking this area still requires from different scholars in different areas. So
yeah, this is an issue how to. It's this one. Click the mouse. The mouse. Yes, I think.
okay.
Okay. Can you speak louder because it's not working? You have to.
No, it's connected to.
Yes, to the camera.
Okay.
So you have to speak up. Thing.
So first, I would like to briefly set some background, some stage for our further discussion. So I will briefly talk about different types of sanctions and what is the status quo in terms of legal regulation of sanctions. And then I will briefly outline what sanctions and type of sanctions were imposed against Russia after its invasion of Ukraine. And then I will turn to the question of sanctions legality and legitimacy. So starting with our introduction, first of all, it's really important to remember that there are different types of sanctions. First of all, there are sanctions which are authorized by the United Nations Security Council. And usually when it comes to these types of sanctions, there is no big legal questions in terms of their legality. This is so-called collective sanction. There is a general consensus in international law and international relations that this is legitimate sanctions if they are authorized. But in order for the sanctions to be authorized, there should be a consensus among the permanent members of the Security Council, which sometimes makes it very hard to reach this decision. And that's why these sanctions were not imposed as a part of this situation between Russia and Ukraine. And also it's important to note that these sanctions have been used more frequently since the end of the Cold War, and leading even some scholars to argue that starting from 90s, we have seen something what is called sanctions decay, meaning that collective sanctions were used quite frequently in order to address different situations. Next category of sanctions is so-called unilateral economic sanctions. These are the type of sanctions which are introduced by individual states based on their domestic laws and regulations and without any authorization received from any supranational organization or international institution. So basically, these are the measures which are introduced based on domestic laws of states, but which might have very broad international implications. And later we will see why this is the case and how they're regulated in international law. And third type of sanctions, probably one of the most interesting ones, and the ones which I would not probably even discuss before the war in Ukraine, but which is sometimes now called or labeled as private sanctions or sanctions of private companies. This is a very unique situation, and it developed primarily because of such a massive exodus of private companies from the Russian market. As of now, there are more than 1,000 companies that have left Russian market as a result of different considerations. Sometimes it's reputational cost, sometimes it's business decision, sometimes it's more like if companies operate in the consumer market, they would like to preserve certain kind of, show some sort of solidarity with Ukraine in this situation. So there are many different types of considerations, but these are one of the most unique developments in terms of this conflict between Ukraine and Russia, that private companies start also showing their position more explicitly, and not as a part of implementation of sanctions, but as their own will, so to say. So the most kind of tricky legal question is the regulation of so-called unilateral economic sanctions. It has been always the case, and starting even from the lack of one set definition, what is the unilateral economic sanction? There have been different terms used, and different countries use in their own domestic regulation, they use different terms. For example, the European Union uses the term restrictive measures. Australia talks about autonomous measures. United States always use term sanctions. If we look again in the academic literature, different authors use different terms. Sometimes you can see it's unilateral sanctions, unilateral economic sanctions, or non-UN sanctions. So there is a lot of definitional ambiguity when it comes to unilateral economic sanctions. But what is more, even if we look how to frame unilateral economic sanctions in public international law discourse, we always face the situation where there is no one term that can cover all the types of measures. So usually it can be either covered by retortions or countermeasures, in some cases third-party countermeasures. So there is no even one legal category that can describe all the diversity of these measures. And now turning even to more intricate question, whether these measures are legal as a matter of principle and whether they are legal with respect to certain international obligations of states. So this is very long-lasting debate, and I just outlined several questions on the slide which have been discussed actually for decades. One of these questions is whether these measures can be equal with the use of force under Article 2.4 of the UN Charter. And this has been already discussed even when the UN Charter was drafted. Actually, Brazil back then tabled a proposal saying that when we are talking about use of force, we should also cover use of economic force in order to reach certain political outcomes. Back then, there was nothing that was put in the text, which lead now again to this discussion being sometimes coming up again and again. So what is the meaning of the term force in Article 2.4 of the UN Charter, and whether it should cover also different types of economic measures, especially if we are talking about very complicated, very severe economic restrictions, which are also basically driven by some political considerations. The next question is, if it doesn't fall under the definition of the use of force, what about the relationship between unilateral economic sanctions and principle of non-intervention? And this has already been discussed even by the ICJ in Nicaragua case, whether economic pressure can be equal to non-intervention and in what cases. So again, there is no clear-cut distinction. So there have been some discussion of these questions, but it still kind of remains mostly a debated question without any clear answers given. Then I also put some other questions regarding whether unilateral economic sanctions can be justified as a countermeasures under the law of state responsibility or as so-called third country countermeasures. If, for example, the state is not directly injured state, but the state says it still feels that it has a right to impose countermeasures in response to certain prior violation of international law. And this issue still remains to be not very clear, and it still raises a lot of debate even till now. And then the last question is probably also very interesting discussion about so-called secondary sanctions. Sanctions which are framed in such way that they not only impose restrictions on your own nationals or companies incorporated in your country, but which have a broad extraterritorial reach and which force companies based in foreign jurisdiction to comply with your domestic regulations, with your domestic sanctions. And it remains to be a very heated debate because in some cases, in particular, the United States was known for imposing these secondary sanctions with respect to Iran, thus preventing many, including European-based banks, of providing legal services, financial services, insurance services to Iranian-based companies. And it has very severe implications for the Iranian economy as well. So then there is a question whether how do these types of measures relate to their principles on the certain jurisdiction in international law. So all these questions, they have been there for decades and they have been discussed by the policymakers, by legal scholars, sometimes by courts, but to a less extent by courts. And there is no clear-cut answer. So basically, once you're talking about unilateral economic sanctions, it's one of how I call it murky legal terrain. So it's very messy, one can say. So it's very messy area of law because there is a lot of principles on which these measures might touch, but there is no clear-cut answer, and it always depends on many factors. So it's always hard to distill some general rule for how to regulate and how these measures are regulated in national law. So now, against this background, we will have a quick look at what sanctions actually were imposed after Russia invaded Ukraine in February this year. So before this, I would like to briefly show you a map that 48 countries in total imposed sanctions, including some small countries, which are not part of the European Union, but which still wanted to show as a sign of solidarity with the measures introduced by the European Union. And all G7 countries introduced measures. And in fact, we will return to this, but this is one of the cases when actually all G7 countries have cooperated a lot in terms of framing sanctions, implementing and enforcing relevant measures. But at the same time, there are a number of countries which explicitly already confirmed that they will not introduce sanctions. And I just spotted I took the list of G20 countries and I outlined the countries which have already explicitly said that they will not impose any restrictive measures against Russia in response to its invasion of Ukraine. So it's quite big countries, big markets, big economies, and if you can see that there is China, India, South Africa, Turkey, and other countries which explicitly confirm that it's not their intention and there is no political will to introduce any restrictive measures against Russia. And now going back to categories of sanctions which were imposed against Russia. So there have been a lot of different rounds of sanctions, and if someone was following, there was a lot of information about what kind of sanctions were introduced. So I tried to group them in terms of their substance of the restrictions that were implemented. So first of all, it's sovereign debt sanctions. It's sanctions which basically made it very hard for Russia to finance its debt, to get access to financial market to finance its debt. But at the same time, one should say that these sanctions have a minor economic effect because in general, Russia doesn't have a lot of sovereign debt as such, as a matter of principle. So next type of sanctions is so-called financial sanctions or sanctions against financial institutions. There are several types of these sanctions. So, it was first of all freezing assets of some financial institutions. Second, it's SWIFT sanctions, so it's kind of prohibition for certain big banks to use this system of SWIFT payments. And the third category of sanctions or financial sanctions is prohibition of clearing transactions from foreign currencies. Then there are targeted individual sanctions. These are very closely tied to what an individual who is targeted as a result of these sanctions. So there are several categories of people who were targeted as a result. First of all, it was first wave of sanctions, which was so-called political elites. So there was they were identified people who are so-called decision makers and policy makers in Russia, and they were targeted. Then there was a group of oligarchs who were targeted, and we have seen also probably in the media, it was well covered that there was their property abroad was seized, their yachts were seized, airplanes, and so on. And the third category, surprisingly, that some of the main propagandist people who work for the media and who were trying to make all sorts of arguments justifying this war against Ukraine were also included in some of the sanction lists, and some of the countries enforced them, prohibiting them from using their property abroad, freezing their accounts abroad, and restricting them to travel to these countries. Mm-hmm. Fourth category of sanctions is so-called technological sanctions, or in other words, enhanced export controls. These sanctions are mainly target access to so-called dual-use goods, as well as some sort of technological advanced solutions which might help Russia to sustain its military capacity and to continue the war against Ukraine. So, and in this respect, there will be interesting questions towards the extraterritorial application of these sanctions, which we will address a bit later. Then, something that came as a very unexpected move was the freezing of central bank assets. So basically, significant portion, some analysts estimate up to 50% of the Russian central bank assets, which were located abroad, were frozen. And they were frozen fast enough to prevent Russia from moving them to other jurisdictions. So this is, and right now with respect to this frozen central bank assets, there is a big discussion whether they should be used as a financial means to finance rebuilding of Ukraine later after the war is over. So there is a big discussion, at least inside of the countries that have frozen these assets, whether these funds should be used in one way or another through certain maybe international mechanisms or under international supervision to finance the reconstruction of Ukraine. But then it's from a legal perspective, this move raises many hard questions which need to be resolved if governments decide to proceed with this move. Then transport sanctions, like as an example of them, I say closing airspace, withdrawal of the MFN treatment. So it's part of the decision of G7 countries to cooperate together on sanctions, they decided to withdraw so-called most favored nation treatment, which is part of the WTO law of multilateral trading system obligations. And with this example, we will discuss it later in details. Then energy sanctions, but then again, energy sanctions were only partial, only to an extent to which countries can't allow them to introduce these restrictions, because still there is a trade in energy resources which finances Russian budget. And then sport and culture sanctions, which have more symbolic meaning, but I think it's still very strong. It sends very strong message in terms of the country is on the wrong side of history with its actions against Ukraine. And probably the last time when I remember when such a strong sport and culture sanctions were introduced was the case of apartheid South Africa. So now turning to the question of sanctions legality. So I decided to discuss this question by 3 examples from the sanctions which have been already put in place against Russia. First of all, it's withdrawal of MFN treatment and WTO law. So before February 24th and before countries withdrew MFN treatment, Russia could trade with other countries that are members of the World Trade Organization based on so-called MFN treatment. This is one of the probably core principles of multilateral trading system, which allows countries to trade with each other on the same terms. So your goods from Israel will be treated the same way as the goods from Russia or goods from China, as a rule. So it's one of its basic non-discrimination principles that once you trade, your trade and the tariffs and other regulations apply in the same way to all these countries, to the goods which come from all these countries. And when G7 decided to withdraw this most nation MFN treatment, they basically, what they did, they started introducing completely different rules to the goods which come from Russia. So some countries, for example, as Canada, now apply universal 35% tariff to the goods that come from Russia. So if before this tariff was not applicable to these goods, now Canada applies the 35% tariff to category of goods that come from Russia. So obviously there is a clear violation of obligation of the countries which introduced these measures, and it's clear violation of their WTO commitments. But at the same time, there has not been filed a formal complaint. There have been some political statements that Russia might consider leaving WTO as such, but there have been no formal complaint lodged before the WTO panel. So, and at the same time, one of the reasons why this might be the case is that potentially WTO law has a number of exceptions which apply to violations. And if you violate your commitments under WTO law, but they can be covered under the exception clauses, then it's considered that as if it's allowed under the multilateral trading system. So basically, looking at the overall situation and context in which these measures were taken, it's possible to say that countries which introduce this restriction and withdraw MFN treatment, they can justify it based on national security exception, which is incorporated in the WTO law. And in fact, there have been 2 cases where the scope of this national security exception has been decided. And the first case in history was the case where Russia invoked national security exception to justify its trade restrictions against Ukraine as a part of the conflict which started in 2014. So, and the WTO adjudicators give very general and broad interpretation, allowing countries to introduce quite wide range of measures which might be justified under national security exception. So talking about second example, where we can talk about whether measures are legal or illegal under international law, it's freezing of central bank assets. So freezing of central bank assets might impede immunity guarantees as are known under customary international law. And here we have to tackle 2 questions. First, whether central bank in general can benefit, or central bank assets can benefit from immunity guarantees. And second question, whether such guarantees can be claimed outside of the court proceedings. The answer to the first question is, in general, is yes, because it's considered that central bank assets should benefit from immunity guarantees. But at the same time, there is still ongoing debate whether these immunity guarantees can exist outside of the court proceedings. And when we are talking about sanctions, we are talking about measures which are imposed not by the court. So sanctions are imposed by the other branches of government and outside of the court proceedings. So the big debate in the literature is whether these guarantees can be also granted outside of the court proceedings. And this question is not resolved yet. And there was a case before International Court of Justice launched by Iran against the United States for its action of freezing central bank assets of Iran and then using it as a payment of compensation in the private litigation cases. And Iran brought a formal claim before International Court of Justice, but unfortunately, the only jurisdictional ground for bringing this case was their bilateral agreement on trade and economic relations, and there was no way how you can put immunity argument inside of the treaty. Well, Iran tried, but in its preliminary decision on jurisdiction, the court said that it falls outside of the scope of this dispute, and that's why there will be no clarification from the International Court of Justice with respect to immunity guarantees and whether central bank assets can be frozen or can be used to pay private claim compensations. So it's a very interesting case, but unfortunately in this case there will be no discussion of scope of immunity guarantees and whether they can be claimed outside of the court proceedings. And third example is extraterritorial application of sanctions. And in this regard, I would like to refer to the US technological sanctions, which sometimes called against Russia, which sometimes called Huawei rule on steroids. So basically, how United States, after Russia invaded Ukraine, they introduced this enhanced export controls prohibiting not only number of technological export to Russia and dual-use goods and increasing the list of goods which cannot be exported to Russia, but also prohibiting export to Russia of any good which is produced anywhere in the world, which is produced with the use of the US technology or with the use of the US software, making it similar to the rule which was targeting Chinese company Huawei, but just now, before it was targeting company Huawei, but now this rule targets the whole Russian market, which makes some commentators to call it Huawei rule on steroids, implying that it has been first time in history when this rule applies to the whole country, to the whole market, actually, prohibiting technological exports. And there is only one exception to cooperating states, meaning that all the G7 countries and also Switzerland, they introduced more or less similar rules in order to avoid their duty to comply with the US sanctions. So they introduced similar regulations just to have an exception and don't report to the United States on their exports in future. And now I would like to conclude my presentation by talking about the question of legitimacy, because we have talked a lot about the question of legality, and we have seen that, first of all, the regulation of economic sanctions, there is no one set of rules that applies. Economic sanctions, they might have raised completely different legal questions in different areas of law. But at the same time, it's interesting to ask a question whether they can be legitimate in these circumstances. And I put few arguments which, in my opinion, might be used to argue in favor of legitimacy of economic sanctions against Russia. So first of all, as it has been already mentioned today, that international law is a system that is based on decentralized enforcement, and that's why it's actions of the states which are aimed at the production of certain values which matter in this respect. So if the states feel strong sense that they have to respond to certain crises and show they implement certain types of measures. So second, it's limited number of available alternatives. If you look at what are the available alternatives for member states of the United Nations, except use of military force, then and when the diplomacy doesn't work, apparently economic sanctions is one of the best alternatives available. Third point is the value of norms violated by Russia. And this is exactly justifies the problems, the severity of economic sanctions which were introduced, because the very cornerstone principles of the UN Charter and of the overall world order have been violated, and there is kind of no easy solutions for the situation. And that's why, taking into account the value of these norms, probably we can say that some of these measures are legitimate. And then if we look at the time frame of sanctions, these sanctions were tightened. So new rounds of sanctions were announced only after further escalation. So there were different time periods, and these sanctions were tightened related to certain actions or inactions of Russia. And then two last points here I would like to briefly mention is that what is particularly interesting in this case is that we have observed the close cooperation of G7 members on the issue of sanctions. So we have seen that the countries try to discuss the framing of the sanctions, that they try to, and then the next point is that they engage in information sharing and they engage in implementation. So there have been transatlantic task force, which was established in the first week of war. It basically shows a lot of interest between states to cooperate on the issue of sanctions, not only in framing sanctions, but also exchange information, enforce sanctions, and implement them. So, and looking at all these arguments overall, I think there can be a point made saying that looking at the issue of sanctions and looking at in what context they were introduced, they can be called legitimate. Although the question of legality still, in some cases, remains unresolved. And again, it's just overall situation as one can see, there is abundance of state practice when it comes to sanctions. There is always abundance of state practice. There is a variety of measures introduced by states in different contexts, pursuing different political objectives, using different types, sometimes extraterritorial sanctions, sometimes sanctions which undermine certain kind of economic relationship between countries. But at the same time, there is a lot of principles which might be implicated as a result of these actions. But at the same time, there is no overarching framework. There is no kind of clear-cut regulation which regulate this type of measures. So a lot is given to the states. And what is even more what adds more to this situation is that there is no any international court which is per se responsible for this type of looking at this type of measures. So if you find that some type of measures might violate WTO obligations, then you can file a case before WTO panel. But then at the same time, we have crisis at WTO, so we do not have appellate body, and there are a number of panel reports which are now appealed and which go into the void. So nothing happens there. And at the same time, if you look at the International Court of Justice, you always have this question of jurisdiction, and it's very hard sometimes to link certain types of violations, especially of customary international law, to a right to bring a case, because the court will just deny jurisdiction. So there is no even some sort of higher authority that can have a look at certain type of measures and discuss whether they are legal, what are the implications of these measures. So we are in a situation where we have abundance of state practice and we have lots of international principles which might be implicated, but at the same time, we don't have one set of rules which regulate these types of measures. This is my presentation. Thank you.